That way, if that is voted down, well, then the procedure is quite okay. And my response to that is this. If that is to be the procedures of the House, what that says to ministers is don't introduce a bill to the House with the intended commencement date, bring it in and confuse the public and everybody, and then when you get to the committee stages, move an amendment to shift it. And I would ask, in terms of the public purpose of this Parliament for the people of New Zealand, how would that procedural approach help the relevance of this Parliament? You get people submitting on a bill, not on the date that was intended, because we ministers are forced into a position of cute amendments during the committee stages to overrule what is nothing more than a sophisticated mechanism that is being attempted to create a filibuster of voting. And that's why, Mr. Speaker, my plea to you is to support the Chair and for common sense to prevail.
I thank honourable members for actually what is a very interesting procedural debate, it's not a debate, procedural discussion under point of order, because it is interesting. I agree with the Honourable Trevor Mallard that we're in actually territory that is without precedent, without clear precedent in New Zealand's parliamentary practice, and therefore it is important, and that's why I've listened very carefully to the points being made, and I think very good points have been made by both sides in the last few minutes. Can I assure the Honourable Darren Hughes that my thinking in this is certainly not governed by the number of amendments in itself, because amendments that are different from each other, there could be any number to a piece of legislation, and the opposition has, or any member has, the absolute right to put amendments that the House hasn't already decided upon, and it is not the crucial issue. You know, there are more substantive issues involved in this particular ruling that I'm about to make. I think the crux of the whole thing does come down to the issue, I think, recognised by Honourable Trevor Mallard, that if we look at what has been a practice in the past in New Zealand, it was mentioned by the Honourable Dr. Nick Smith, that where the government, usually the government, moves an amendment to a date and the committee votes on that, once that is accepted, then any other amendments are ruled out. And we've had that as a clear precedent in New Zealand. What has not been such a clear precedent in New Zealand, and is an issue that I am going to rule on at this stage and suggest, though, a way forward, is the other side of that mention in Erskine May that the Chair, the Honourable Rick Barker, has emphasised, and that is in Erskine May, they emphasise also that a chairperson has to also consider the admissibility of amendments that are substantially the same as an amendment that has already been negatived by the committee. Now, that is something that has not been our common practice in New Zealand, I think it's fair to say. Yet, I think what the Honourable Dr. Nick Smith pointed out in his point of order was our not having in the past accepted that practice has led to a fairly unsatisfactory situation whereby it may lead to the government doing exactly what the member suggested and leaving out a date, so that an amendment can be moved by the government to put a date in, and any other dates then are ruled out. I think the Honourable Trevor Mallard, though, has made an interesting point in accepting the basis of Erskine May's advice on page 401 there. The Honourable Trevor Mallard pointed out that what is considered to be substantially different, and when it comes to dates, Honourable Trevor Mallard pointed out is a date that's 6 months different, substantially different compared with one that's only 1 or 2 days different. And what I'd like to put to members, I make it very clear to members, I'm going to rule in favour of the Chair's position on this, that the Chair has found that the amendments are not admissible because the House has already negatived an amendment that is substantially the same as those other amendments, and therefore the Chair, the Honourable Rick Barker, has ruled them out, and I'm going to support that ruling. In doing so, though, I'd like to suggest to members that this matter be looked at further by the Standing Orders Committee, because I think what is different in our practice from the practice at Westminster is at Westminster the chair can select from, say, a range of dates, 2 or 3 amendments that are substantially different, test them, and once they're tested, the rest are out. And it may be that we should look at a similar, and in our procedures in this Parliament, we don't have the ability for the chair to choose where there are a lot of amendments that are very, very similar, to choose some that maybe could be considered to be different. And I think it's something I'd like to have the Standing Orders Committee look at for the future, because it would overcome any concern, because don't forget, as Speaker, I am genuinely concerned in the interests of the minority, and it would overcome any concerns that about the chair deciding what might be substantially different, because then the House or the committee would have decided that in the matter of 2 or 3 amendments that could be voted on reasonably, in a reasonable space of time, and that would then resolve that matter so that the chair is not having to make that judgment totally on their own. And that's what I'd like to have the Standing Orders Committee look at. But at the moment, I'm ruling in favour of the position adopted by the chair of the committee, that because the House has already negatived an amendment that is substantially the same as these further amendments, that they are ruled out. I thank all the members. Point of order, the Honourable Trevor Mallard.
And not to in any way litigate your ruling. It's one which I think will consider carefully, and I hope the Standing Orders Committee does as well. Mr Speaker, I seek leave for there to be a question time at 2 p.m. tomorrow. That's the 25th on outside time, with the normal arrangements for the lodging of questions.
Leave is sought for that course of action. Is there any objection? There is objection.
Point of order, I didn't hear objection. I saw a nod but not a word.
Order. There is a concern about whether or not I correctly ruled on the matter. I'm very happy to put the leave again. Leave is sought for that course of action. Is there any objection? There is objection. I declare the House back...
Point of order, Mr Speaker.
Point of order, the Honourable Jerry Brown.
Mr Speaker, I'd like to make it very clear that we're always open to negotiate these matters with the opposition when they behave in a reasonable fashion.
No, order.
Of course we'll consider such a request.
No, order. I'm not sure what... the Minister's... no, order. I'm on my feet, and that is not a point of order. The member's perfectly liberty to negotiate with whoever he wishes, but it's not actually a point of order. I declare the House back in committee in consideration of the bill.